This film is a bit darker in nature. How was it getting in touch with your darker side?
It was just more like all the facades that I put up, I just had like let go, so you guys got to see the real me. I'm just a dark, horrible person, and I just got to let my flag fly. So there you go, this is the real me.
Wayfair and Kevin Fritz have stepped forward in support of content creators, firmly opposing Blake Lively's increasingly controversial legal actions. Lively has filed motions claiming she's the target of an orchestrated smear campaign allegedly led by Melissa Nathan, whom she accuses of disseminating damaging, untraceable narratives. However, a letter dated today and submitted to the judge counters Lively's arguments, challenging her attempt to portray herself as the victim of public backlash and accusing Nathan of unjustly being the cause of it. According to the response, Lively's claims rest on the idea that Wayfair and associated parties have launched a covert media campaign to tarnish her image. The filing dismantles this notion, highlighting the contradiction in Lively calling the campaign untraceable, while simultaneously identifying specific news stories and authors that she takes issue with. This contradiction, the response argues, undermines her rationale for using the federal court system and civil procedure rules to demand information that she already knows. Blake Lively, they argue, knows precisely who she is targeting with subpoenas. This appears to be a strategic attempt to shift blame for a backlash that arose organically from the public. The motion points out that Lively's own documents concede that even after months of discovery, receiving thousands of pages of documents, and issuing dozens of subpoenas, she has found no evidence of a coordinated smear campaign by Wayfair or its affiliates. Instead, they assert that these parties merely exercised their right to protect their reputations after Lively's claims became public. The filing references prior legal precedent, including a decision by Judge Lyman dismissing a retaliation claim over the publication of a letter disputing harassment allegations, concluding that such actions do not amount to employment retaliation. The same reasoning is applied here. Defending one's reputation is not a punishable offense. Moreover, the motion notes that TAG, the media consulting firm, was not even retained until early August 2024, making Lively's assertion that they orchestrated a coordinated campaign within a 2-week span both improbable and unsupported by evidence. Instead of acknowledging that the backlash is the result of public reaction, Lively seeks to blame TAG, despite failing to cite any concrete proof. Her legal team alleges that individuals named in interrogatory responses have spoken publicly about the lawsuit and Lively herself at TAG's direction. However, the scope of the interrogatories simply requested names of anyone with whom TAG communicated regarding Lively, her allegations, or this lawsuit since May 2024. Those responses include only individuals to whom TAG provided harmless statements from Wayfair's legal counsel in reply to media inquiries, just as Lively's legal team has done. Despite this, Lively portrays these standard communications as sinister. The response makes clear, TAG did not contact any content creators about this matter or the underlying allegations until 2025, when they were asked to provide official statements. The narrative Lively spins around this communication is deeply misleading. Her motion further claims that confidentiality and AEO designations on the interrogatory responses are influencing content creators, implying they have now labeled her as the aggressor and equated her discovery tactics with an orchestrated smear campaign. However, this claim is dismissed as baseless. According to the filing, creators were simply reacting to being subpoenaed, an action that Lively initiated herself. If she wished to avoid backlash, she could have avoided issuing invasive subpoenas. The argument continues. If these interrogatory responses are only accessible to legal counsel, they cannot possibly be impacting public opinion. The true trigger for public criticism was Lively's decision to subpoena Google, YouTube, TikTok, and X, Twitter, demanding sensitive account data, including phone numbers and financial records, from specific creators. Articles have already pointed out the irony. In a sexual harassment lawsuit involving Justin Baldoni, Lively's attempt to garner sympathy backfired after the public learned she was targeting pro-Baldoni creators with overreaching subpoenas. Among all the creators and journalists named in the interrogatory responses, only one received such a subpoena, believed to be Andy from Popcorn Planet, whom Lively also designated AEO after he merely received a public statement. The motion reiterates that TAG's responses never admitted to any campaign to damage Lively's reputation. Moreover, had Lively's legal team continued discussions instead of rushing to court, none of this would have been necessary. The filing also notes that her motion lacked legal precedent to justify the removal of confidentiality designations, showing the real motive, to shift blame to TAG and Wayfair for the fallout from her own aggressive legal tactics. According to TAG, The identities of reporters and creators they've communicated with are proprietary, and disclosing them could result in significant business harm, qualifying as trade secrets under protective court orders. Lively's team did not initially dispute this. But shortly after, she issued subpoenas to platforms like Google, TikTok, and X, which unveiled creators' identities in what appears to be an aggressive phishing expedition. The majority of those listed were not major public figures or large accounts. In fact, some had only a few followers or inactive channels. The listed creators include Blossom Talk, Bobpin YouTube, Anna OP, Spill Sesh, Lethal Lauren, Without a Crystal Ball, Fame Key, Fani, Popcorn Planet, Sweet and Salty, Cassidy OC, JZY News, and others, many of whom had little to no public reach before this controversy. Even more strangely, the TikTok and X subpoenas included anonymous usernames, private individuals, and small accounts that had simply posted opinions. These are not influential media figures but regular users, some with just a handful of followers. Despite this, Lively alleged in court that Melissa Nathan was deliberately withholding information and interfering with communications. She even accused Andy, Popcorn Planet, of publishing a recorded call with a law office receptionist, ignoring the fact that the call was reportedly made on a recorded line. Lively's actions appear aimed at diverting attention from the organic backlash caused by her own behavior and legal overreach. Her subpoenas have put creators on the defensive and stirred widespread criticism, not because of a smear campaign, but because of public reaction to her litigation tactics. The accusation that these creators are part of an unlawful operation to harm her reputation is serious, suggesting they are complicit in crimes, without evidence, and demanding their private financial records without justification. Even when questioned, Lively's team allegedly could not cite a single statement or video proving these creators were part of a coordinated effort. The response highlights that Lively is attempting to weaponize the court to punish criticism. Despite obtaining thousands of documents, dozens of subpoenas, and formal responses, she still cannot show that Wayfair or its affiliates organized any campaign. They simply responded publicly to her very public allegations. This is a troubling pattern, one where Lively accuses others, but refuses to take responsibility for the fallout from her own choices. Despite being a global celebrity married to a multimillionaire actor and entrepreneur, she's going after small content creators, some with barely any reach, as if they pose a legitimate threat. The filing concludes that public figures must accept scrutiny. Many celebrities face far worse backlash and move on without retaliating legally. Figures like Taylor Swift, Kim Kardashian, or Selena Gomez have dealt with widespread criticism without launching lawsuits against users on social media. Lively, however, seems intent on blaming everyone but herself. Instead of issuing apologies or engaging with critics constructively, such as domestic violence organizations or advocacy groups, she's issued subpoenas and targeted creators. The result? A lawsuit that increasingly appears overreaching and retaliatory. And yet, the court continues to entertain it. Criticism is not harassment. Backlash is not a smear campaign. The public has the right to respond to the behavior of public figures. The judge overseeing this case, criticized here for allowing it to drag on, is being urged to recognize the dangers of allowing legal tools to be misused in this way. Wayfair and Kevin Fritz have now made it clear they will no longer stand by as Lively falsely accuses creators of crimes without evidence. They've agreed to remove confidentiality from their documents to prove they have nothing to hide and to show that the backlash Lively faces is a product of her own making, not a conspiracy.